Probably the easiest thing to do is start by introducing ourselves. I'm Paul Gowder. I have a moral as well as an aesthetic objection to name tags. I am a former farm worker justice lawyer in Oregon who's brought a lot of litigation related to farm worker wages and conditions of employment. I've also a former civil rights lawyer in the DC area. I've actually left the practice of law at the moment and am working on a PhD at Stanford University in political theory, which is basically the ethics of justice and democracy. So I like to think that somehow locked up inside my brain there are issues relating to both the legal as well as the moral questions surrounding farm worker justice. And Emily?
My name is Emily Rocky, and I can offer the practical, more face-to-face relationships that we might have with apprenticeships. I am an apprentice currently at the Milk Organica Farm in North County, San Diego, north of Escondido. So yeah, today what I have to offer is kind of my own perspective on things based on my experience, and maybe a little bit to contribute to an overall dialogue that we want to have with you guys. So,
are we clearly audible in the back of the room, by the way? Alright. So, I guess I can begin unless you want to.
Go for it.
So I just want to give you guys a quick sort of 10-minute overview of some of the issues surrounding farm worker apprenticeships, internships. The name doesn't really matter. There's no sort of legal or moral significance to calling it, apprentices, interns, mentees, student workers, pick your name. Quick disclaimer, of course, and I say this because as a sort of lawyer/ex-lawyer, we're trained to say this. Please don't take anything I say as legal advice. Please don't go out and run some sort of legally significant decision based on what I say. Talk to counsel, particularly since I've admitted to the bars of 4 states, but California isn't one of them. So please don't do this to me. Or yourself, more importantly. Now, first of all, a quick rundown of some of the legal issues with a sort of arrangement. So by internships, apprenticeships, and so forth, I think what we all understand here is a situation where somebody goes to a farm to work on the farm, either without pay, with pay, what lawyers call in kind, that is in the forms of goods or services, or with pay that doesn't add up to the amount that usually constitutes minimum wage. And so there are a lot of legal issues with this. There are both state and federal laws that interact with this. There's state minimum wage laws in addition to federal minimum wage laws. There's workers' compensation laws. There's unemployment compensation laws. There are tax laws. And there's no way that we can run over all of the legal issues in anything less than a several-hour session. But what I can do for you is highlight the most important federal law, which is the Fair Labor Standards Act, the federal minimum wage law. So, the minimum wage provision of the Fair Labor Standards Act applies to most farms, requiring that employees be paid the federal minimum wage, whatever that is right now, 7 something an hour perhaps. It's on posters all over the place, you can find it. Interestingly, the overtime provisions of that law do not apply to agricultural employees. It's often difficult to determine who counts as an agricultural employee because the Department of Labor can be really titchy about this sort of thing and has been known to say that, for example, people who work in support roles on farms but who aren't actually involved in farming don't count as agricultural employees and have to be paid overtime. But for present purposes, we can suppose that overtime doesn't actually apply. The minimum wage doesn't actually apply to several categories of farm employees. One category is on very small farms, by which we mean farms employing less than what they call 500 man-days, lovely sexist term there, of labor, which amounts to about 7 full-time employees, give or take, in a year. This is a very difficult exception to meet, but oftentimes small farms can get out of the federal minimum wage law, which does not necessarily mean that they can get out of state minimum wage laws, mind you, but they can. There are also exemptions for people who are paid on a piecework basis, although that too is very complicated. Exemptions for family members on family farms and so forth. But ordinarily, it's safe to assume that the minimum wage laws will apply to someone who works on a farm, even if we call them an intern, an apprentice, and so forth. And so that such people will have to be paid the minimum wage. Here's an exception. The Department of Labor, which has promulgated regulations implementing the Fair Labor Standards Act, recognizes that there are some people who are genuine interns, who are genuinely there for educational purposes, rather than for, the purpose of contributing to the employer's bottom line. And so, ordinarily, an intern or an apprentice or whatever won't be considered an employee under federal law if all of the following are true. 1, there's training given similar to what would be given in an academic institution. 2, the training is primarily for the benefit of the trainees. 3, the trainees don't displace regular employees, but work under their close observation. 4, the employer doesn't derive immediate advantage from the activities of the trainees. There are a couple other provisions, but the main ones are this issue of whether the trainees or the interns displace regular employees or not, and whether the employer derives sort of an immediate advantage. So the idea here is if a farm is hiring people, bringing people on as interns to train them, and actually sort of giving from the employer's time to do that, then they're not considered employees. But if the employer would have to hire someone to do the same job, unless, the unpaid intern was there, then ordinarily they will be considered employees, and they'll be subject to the minimum wage laws. So, that's the main issue. As I said, there are a lot of other legal issues, particularly state laws can often be more stringent than federal laws on the terms of minimum wage. But the main thing, sort of the main way to make internships legal is to make them, or apprenticeships, or whatever you want to call them, is to really make them internships. That is, to genuinely have interns, in addition to regular employees, who can help out but who don't displace regular employees. Now, of course, this is an issue, because part of the reason that this is beneficial for farmers, and particularly for small sustainable farmers, is that it's hard to pay all that labor, and sustainable farmers are in a tough economic market as it is. This is true, but let's talk about some of the moral issues on the other side. So yes, these are legitimate concerns. Life is difficult economically for small farmers, and I think everybody in this room knows that. But, so consider the issue number one from the perspective of the workers. So it seems to me that there's a basic question of justice as to what extent should people ever be employed for very low or no pay? Well, one answer is, well, it's a voluntary arrangement, and many times many people want to be employed for low or no pay. In other words, they seek out this opportunity for the purposes of training. Nonetheless, there's still, I think, a legitimate concern. I mean, some transactions are wrong, even if they're voluntary. Imagine not a good faith sort of small sustainable farmer, but a big, evil factory farm doing this, just to sort of take it out of the sympathetic territory for a moment. And think about whether that might involve exploiting a harsh employment market. So here's a thought experiment. Suppose you're dying of thirst in the desert, and you come across me, and I have a bottle of water, and I offer to sell you that bottle of water for, $10,000. No, I mean, that's a legal transaction. That's a voluntary transaction.